There was no break-in.
It really seems like it's blowing it up under a microscope.
Yeah. Yeah, I mean, that's part of the power of the internet, right?
And legal experts say that kind of attention isn't uncommon when a case is revisited in a doc.
So this is one thing that is a reliable way to get eyeballs on your platform.
But that attention can cut both ways, especially after a case is already closed.
Post-trial, it often has the other effect, where they have taken a deep dive into a criminal case and really explored and presented significant questions about the validity of the conviction.
And in some cases, Case Western Reserve Professor Benza says it can become part of a longer legal strategy.
The defendants will be willing to talk to try to keep their story out in front of the public, because we know if you get some positive publicity about issues in your case, it makes it easier to maybe get back into a court and have some review.
But not every motivation, he says, is legal or even about appeals. Sometimes it's fame. Yet he warns when true crimes are repackaged for audiences, perception can overshadow reality, causing real harm.
And that can have very negative consequences for those people who are touched by this. What actually happened, what is in the case, isn't the reality anymore, because the reality gets supplanted by the Netflix Law and Order episode.
The black box doesn't lie. 100 miles per hour, full throttle, 0 brakes. In the final 3 seconds before the Toyota Camry exploded into that brick wall in Strongsville, Ohio, someone made a choice. 2 people died. The only survivor says she remembers nothing. But prosecutors say she remembers everything because she planned it. 17 years old, her boyfriend in the passenger seat, his friend in the back. And a judge who would later say she had a mission and she executed it with precision. So who is Mackenzie Shirilla really? A murderer, a victim of her own body, or something the courts haven't fully figured out yet? This is the story that divided a nation. And it's far from over. She had a name before she had a verdict. Mackenzie Shirilla grew up in Strongsville, Ohio, one of those quiet Cleveland suburbs where the lawns are neat, the schools are decent, and nothing much ever happens. She was someone's daughter, someone's girlfriend, a teenager with a TikTok, a car, and what everyone around her thought was a future. Nobody writes true crime documentaries about girls like that. Until they do. To understand what happened on that July morning in 2022, you have to understand what was happening long before the car ever left the driveway. Mackenzie and Dominic Russo had been together for nearly 4 years. She was 17, he was 20. By most accounts, their relationship was intense, the kind of connection that teenagers often confuse with destiny. His mother, Christine Russo, would later testify that her son and Mackenzie had been inseparable. 4 years is a long time at that age, long enough to build something real, long enough prosecutors would argue to build something dangerous. Because beneath the surface of that relationship lived something uglier. Text messages retrieved from their phones painted a portrait of 2 young people locked in a cycle of conflict neither seemed able to escape. Heated exchanges, controlling behavior, emotional volatility that escalated, cooled, then escalated again. The kind of dynamic that counselors warn about and that teenagers, drowning in first love, rarely recognize for what it is. Whatever was between them, it wasn't simple, and Davion Flanagan, 19 years old, full of life, was simply along for the ride that night. A friend, a passenger, a young man whose only mistake was trusting someone behind a wheel. July 31, 2022 began like countless other summer days in Northeast Ohio. Warm, unremarkable, the kind of day that dissolves into memory before it even ends. Mackenzie got behind the wheel of a Toyota Camry. Dominic sat beside her. Davion settled into the back. 3 young people, 1 car. A road stretching ahead of them with no particular destination, or so it seemed. Surveillance cameras along the route captured the vehicle moving through the streets of Strongsville in the early morning hours. What those cameras showed would become central to everything that followed. Investigators studying the footage noted something that prosecutors would later describe as deliberate reconnaissance, a vehicle tracing a specific path, as though the driver already knew exactly where she was going. Then came the black box. That small, unfeeling device buried inside the Camry recorded every mechanical truth of those final moments. No emotion, no explanation, just data. The accelerator pressed to 100% capacity. No brake pressure applied. None, not a tap, not a flinch. Speed climbing past 100 miles per hour on a surface road. And then impact. The Camry struck a brick commercial building with catastrophic force. Dominic Russo and Davion Flanagan were killed instantly. Mackenzie Shirilla survived, pulled from wreckage that should have claimed all 3 lives, rushed to hospital with serious injuries. First responders arrived at a scene of devastation. 2 young men gone before paramedics could reach them. A teenage girl breathing but broken, and a brick wall that had absorbed the full weight of whatever decision had been made in those final seconds. When investigators began piecing together the hours and days before the crash, something shifted in how they viewed the incident. This was no longer looking like an accident. Evidence emerged suggesting Shirilla had traveled that same route previously, not on July 31st, but before, days earlier, as though she had visited the location in advance, studied it, measured it against some interior calculation only she understood. Combined with the black box data, combined with the text messages, combined with a witness who came forward claiming he had heard Shirilla threaten to wreck the car during an argument weeks prior, the picture prosecutors began assembling was not of a grieving survivor. It was of a planner, a young woman who, they argued, had decided that if she couldn't have control over her relationship, she would exercise the only control remaining to her. Final, irreversible, absolute control. Her defense told a completely different story. Mackenzie Shirilla, they argued, suffered from postural orthostatic tachycardia syndrome, a real documented autonomic nervous system condition that can cause sudden loss of consciousness without warning. She didn't accelerate toward that wall. Her body failed her. She blacked out. She remembered nothing because there was nothing to remember. 2 stories. 1 car. 2 dead. 1 survivor. And somewhere between the black box numbers and a medical diagnosis, the truth was waiting. Courtrooms have a particular kind of silence. Not the silence of empty spaces, but the silence of people holding their breath, waiting, measuring every word against what they already believe, hoping the next sentence confirms it. On August 7, 2023, that silence settled over Cuyahoga County Court of Common Pleas like a second atmosphere. Mackenzie Shirilla, now 18, no longer the teenager behind the wheel, walked into a room where her entire existence would be condensed into evidence, arguments, and ultimately, a single judgment. She had chosen a bench trial, no jury, no 12 strangers weighing sympathy against facts, just one person, one mind, one woman with the authority to look at everything the prosecution and defense had assembled and decide what it meant. That woman was Judge Nancy Margaret Russo. The same last name as the boyfriend Mackenzie was accused of killing. No relation, but in a case already saturated with cruel ironies, that coincidence felt almost theatrical. The prosecution moved with precision. Their opening argument framed Mackenzie not as a troubled teenager or a girl in a destructive relationship, but as something far more calculated. A young woman who had surveilled a location, who had driven that route before the morning everything ended, who had pressed an accelerator to its absolute limit and lifted not a single finger toward the brake pedal. They showed the surveillance footage, jurors or rather. The judge watched a vehicle moving through quiet Strongsville streets in the early hours of a summer morning, unhurried, deliberate, following a path toward a destination that, prosecutors argued, had already been chosen. Then came the black box readout, Cold, numerical, absolute. 100% throttle, 0 braking, velocity exceeding 100 miles per hour on a road built for nothing close to that speed. The data made no allowances for grief, for shock, for alternative interpretations. It simply recorded what the machine experienced in those final seconds, and then the text messages. Page after page of exchanges between Mackenzie and Dominic, reconstructed, presented, dissected. Prosecutors highlighted patterns of control, jealousy, and escalating emotional intensity. A relationship fraying at edges, both participants seemed desperate to hold together, but pulling in opposite directions with increasing force. Then came the witness nobody expected to matter quite so much. Christopher Martin, a friend connected to the Russo family, took the stand and delivered testimony that landed like a stone through glass. Weeks before the crash, he claimed, he had overheard Mackenzie during an argument with Dominic. He had heard her say clearly, directly, that she was going to wreck the car. The courtroom absorbed that. Under cross-examination, Martin acknowledged he had told nobody at the time. No police report. No warning passed along to Dominic or his family. He had heard what he described as a threat and filed it somewhere in the back of his memory, where it stayed until investigators came looking. Defense attorneys challenged his credibility, questioned his timing, suggested his loyalty to the Russo family colored his recollection. But the words were already in the room. "I'm going to wreck this car." Words, once spoken aloud in a courtroom, have a way of echoing. The defense constructed their counter-narrative carefully. Mackenzie Shirilla had POTS, Postural Orthostatic Tachycardia syndrome. Her attorneys explained the condition in detail. An autonomic dysfunction that disrupts the body's ability to regulate heart rate and blood pressure, particularly during positional changes or periods of stress. Episodes could arrive without warning. Consciousness could slip away in seconds, leaving a person physically present but neurologically absent. She blacked out, they argued. Her foot may have pressed the accelerator involuntarily during a sudden medical episode. The absence of braking wasn't a choice. It was the absence of awareness. A body running without a driver. They pointed to her injuries. A person engineering their own destruction at 100 miles per hour would have anticipated impact, would have tensed, prepared, braced. Mackenzie Shirilla was hospitalized with severe trauma. Didn't that suggest she never saw it coming? Prosecutors countered without hesitation. Survival, they argued, proved nothing about intent. The injuries were consistent with impact at extreme velocity, not with any absence of knowledge. And critically, no medical professional had formally evaluated or documented a POTS episode of this nature, with this consequence at this precise moment. The defense was asking the court to accept a medical explanation that conveniently answered every uncomfortable question. Judge Nancy Margaret Russo deliberated. And on August 14, 2023, she returned with findings that would reverberate far beyond that courtroom. Guilty. Not on one count, not on two, on 12 separate felony charges. 4 counts of murder, felonious assault, 2 counts of aggravated vehicular homicide, drug possession, possessing criminal tools. 12. As she delivered her verdict, Judge Russo did something unusual for a jurist trained in restraint and procedural language. She spoke plainly, vividly, with what sounded almost like controlled fury directed at the choices of a teenager who had sat before her. She described watching the surveillance footage. She described the transformation she observed, a vehicle moving normally through familiar streets, then becoming something else entirely, something purposeful, something terminal. She had a mission, the judge said, and she executed it with precision. Mackenzie Shirilla, sitting in that courtroom, wept, whether those were tears of genuine devastation or the collapse of a carefully maintained composure. Nobody in that room could say with certainty. The sentence came shortly after. Life in prison, parole eligibility after 15 years served, 2 concurrent terms running simultaneously, accounting for both lives extinguished on that Strongsville road. She was 18 years old when the gavel came down. Dominic Russo would never be any age again. Neither would Davion Flanagan. Outside the courthouse, 2 families exhaled grief in completely opposite directions. The Russo and Flanagan families felt the particular, complicated relief of people who had waited over a year for acknowledgement that their loss meant something, that the law had looked at what happened and called it what they always believed it was: murder. The Shirilla family felt something entirely different. Steve Shirilla, Mackenzie's father, spoke to cameras with the quiet intensity of a man who had watched his daughter convicted of something he was certain she hadn't done. He didn't rage. He didn't collapse. He made a promise, the kind that parents make when the alternative, acceptance, is simply not available to them. They would keep fighting. A verdict, he seemed to understand, was not necessarily the end of anything. In the American legal system, endings are rarely that clean. Mackenzie Shirilla was transferred to the Ohio Reformatory for Women, where she remains today, older now, navigating an institution built for people the courts have decided society needs separating from. Her lawyers were already preparing arguments before the cell door closed. Because somewhere in the record of her trial, they believed, was a mistake, not just a strategic error, a constitutional one, a failure so fundamental it had potentially sent a young woman to prison without the full picture ever being placed before the person deciding her fate, the medical evidence, the POTS documentation, the expert testimony that her original attorney never brought into that courtroom. It hadn't disappeared. It was waiting. And the fight for Mackenzie Shirilla, the real fight, the one that would outlast the headlines and the documentary and the social media debates, was only just finding its shape. Prison has a rhythm. Wait, count, eat, wait, repeat. For Mackenzie Shirilla, now housed inside the Ohio Reformatory for Women, that rhythm became the architecture of her days, structured, institutional, indifferent to whatever argument was still being made on her behalf in courtrooms she could no longer physically occupy. She was 18 when the doors closed behind her, every appeal filed, every petition drafted, every legal maneuver executed by attorneys working through stacks of transcripts and case law. All of it happened at a distance from the young woman at the center of it. She could only wait, trust, hope that somewhere in the machinery of post-conviction law, something would catch. Outside those walls, however, nothing was standing still. Her original legal team filed the first appeal in September 2023, barely weeks after the verdict landed. They identified what they believed were errors embedded in the trial proceedings, procedural missteps, evidentiary questions, arguments the defense felt deserved deeper scrutiny than a single bench trial had afforded. The Ohio 8th District Court of Appeals examined the submission carefully. Then, in September 2024, they upheld the conviction entirely. The panel found no merit sufficient to disturb what Judge Nancy Margaret Russo had determined 14 months earlier. The arguments, however passionately constructed, did not move the appellate bench, strike one. But Mackenzie's family had not hired her original attorneys to carry this forward. Somewhere between the conviction and the appellate ruling, a new legal team entered the picture, lawyers who looked at the trial record with fresh eyes and arrived at a conclusion that would drive every subsequent filing. Something had been left out. Something significant. The centerpiece of the new legal argument was both medical and constitutional. Mackenzie Shirilla, her new attorneys contended, suffered from a documented condition, postural orthostatic tachycardia syndrome, that could directly account for what happened inside that Camry during those final, fatal seconds. This was not a theoretical defense conjured after the fact. Medical history existed. Records existed. Expert analysis was available from neurological specialists, prepared to testify about how a POTS episode could plausibly produce exactly the physiological state Mackenzie described. Unconscious, unresponsive foot pressed against an accelerator she could no longer feel. Her original trial attorney, the new team argued, had never brought any of it forward. Not the records, not the experts, not the clinical framework that might have given Judge Russo an alternative lens through which to evaluate the black box data. In American constitutional law, this argument carries a specific name and a specific weight: ineffective assistance of counsel. It is among the most serious claims a convicted person can raise because it strikes at the integrity of the trial itself. If true, it means Mackenzie Shirilla was not adequately represented during the proceeding that determined the rest of her life. On April 3, 2024, her new attorneys formally submitted a supplemental post-conviction relief petition built around this argument, alongside supporting expert opinion from medical professionals who had reviewed her history. The petition was substantive, detailed, carefully assembled. It was also, by the cold measure of Ohio statutory law, fatally compromised before a single judge read a word of it. Here is where the story takes a turn that defies easy categorization as either justice or injustice. Because what happened next was simultaneously procedurally correct and humanly devastating. Under Ohio law, defendants pursuing post-conviction relief have exactly 365 days from the date their trial transcript is filed during direct appeal to submit their petition. Not 366, not 370, 365. The deadline in Mackenzie Shirilla's case fell on October 23, 2024. Her attorneys filed on October 24th. One day, the explanation that emerged was almost unbearable in its mundaneness: a leap year miscalculation. February 2024 had contained 29 days rather than 28. Somewhere in the arithmetic of counting forward 365 days, that single additional February day had been overlooked, shifting everything by exactly 24 hours. 24 hours that, under Ohio law, stripped the court of jurisdiction to consider anything on its merits. Judge Nancy Margaret Russo, again presiding, ruled without ambiguity. The petition was time-barred. The court lacked legal authority to examine whether the medical evidence was credible, whether the original attorney had failed constitutionally, whether any of the arguments had merit whatsoever. Procedure had foreclosed substance entirely. The defense appealed that ruling immediately. In March 2026, the Ohio 8th District Court of Appeals affirmed the denial. The filing had been late. The law was clear. The outcome stood. One final doorway remained: the Supreme Court of Ohio. Shirilla's legal team submitted their appeal, arguing that dismissing potentially exculpatory constitutional claims on a one-day technicality produced a manifest injustice incompatible with due process. The Supreme Court declined to hear it. No explanation offered, no dissent published, simply declined. The door closed, then came the documentary. Netflix released The Crash in May 2026, and with it arrived something the legal system had not provided: an audience of millions given access to the full complexity of a case that courtrooms had processed through the narrow filter of admissible evidence and procedural rules. Viewers watched the surveillance footage. They heard the black box numbers. They encountered the text messages, the witness testimony, the POTS defense, the one-day missed deadline, and they argued. Loudly, persistently, across social media platforms and comment sections and group chats and dinner tables. The same fundamental disagreement that had divided observers since August 2023 reasserted itself with fresh intensity. Some watched the footage and saw exactly what Judge Russo described: deliberate acceleration, zero hesitation, a mission executed. They looked at the reconnaissance evidence, the threatening words a witness claimed to have heard, the toxic relationship dynamic, and arrived at the same place the court did. Others watched a 17-year-old girl and saw something different. They saw a medical condition that was real, documented, and never properly presented. They saw a one-day filing error swallowing a constitutional argument whole. They saw a legal system that had processed a teenager through its machinery and produced a result that may or may not have incorporated everything relevant to understanding what genuinely occurred. The documentary included something else: Mackenzie Shirilla herself, her first public interview since conviction. Speaking from inside the Ohio Reformatory for Women, older now, quieter, carrying whatever incarceration does to a person across 3 years of appeals and denials and courtroom decisions she could only hear about secondhand. She maintained her innocence. Of course she did, cynics would say. Convicted killers always do. But her father's words, delivered to cameras with that same steady, undefeated conviction, stayed with viewers long after the credits finished rolling. Show me one piece of evidence, one, that says she did this on purpose. As of today, every formal legal avenue Mackenzie Shirilla's team pursued has been exhausted or denied. The conviction stands. The sentence stands. The Ohio Reformatory for Women remains her address for the foreseeable future, unless something extraordinary shifts the landscape. A federal habeas corpus petition, newly discovered evidence, a legal development nobody has yet anticipated. She will be eligible for parole consideration when she has served 15 years. That places her first possible hearing sometime around 2037 or 2038. She would be approximately 33 years old. Dominic Russo and Davion Flanagan, permanently frozen at 20 and 19 respectively, will have been gone for 15 years by then.